to ward off any background noise and feed. If you would like to ask a question or make a comment, please use the chat section of your dashboard. During the CLE, we will announce a code and also provide it in the chat box section. You will need to enter this code in your evaluation and attorney affirmations forms in order to receive credit for this course. The forms can be found in the handout section of your dashboard. CLE and CE credits will be provided by AmTrust Title on behalf of the New York State Continuing Legal Education Board. No credit shall be awarded for attending a portion of a course or portion of a session. Without further ado, I would like to introduce to you our speakers for today's program. Margaret Ling, Underwriting Counsel at AmTrust Title, and Peter Carozzo, Chief Legal Counsel at Cornerstone Land Abstract. Margaret.
Thank you so much, Anuska, and thank you for all of your help from our AmTrust family to get this thing going today. Welcome, everybody, and good morning. My name is Margaret Lang, and as Anuska had said, I'm the Underwriting Counsel in the New York Agency Department of AmTrust Title. Today, we're going to be talking about due diligence and residential real estate transactions. I am really excited and honored to be sharing the podium with my esteemed colleague, Peter Carozzo, who's the Chief Counsel at Cornerstone Abstract. I have been at AmTrust since April, and I'm thrilled to be back at the underwriter. I've been in underwriting and the title insurance industry for over 25 years. I started in private practice as a real estate attorney. I've worked on the underwriter and the agency level from all the way from agency all the way up to claims at First American. I'm also a graduate of Barnard College and New York Law School. Everyone knows I sit on many board of directors. I'm very proud that I'm the new co-chair of the Real Property Committee at New York County Lawyers. I still continue for 15 years, and many of you who are here today have attended my CLEs. I continue to be the co-chair of the Real Property Committee at the Asian American Bar Association of New York. And I do my best in the 55 minutes we have today to bring practical knowledge to all of you and so that you will continue to learn. We're always learning the latest and the greatest. Particularly today, we're focusing on residential real estate transactions. Peter, I'm going to read briefly, and I learned a little bit reading his bio. He was admitted to the bar in 1997. He's a graduate of St. John's School of Law and then went on to get an LLM. I know Peter probably at the beginning of my title career, which is in 1995. And I did not know that he was a professor. I was very, it was wonderful to read because I love the Constitution, that he taught constitutional law. He's got an LLM, is published widely in his law reviews on the history of the American mortgage. And he's a true Renaissance man. And I am just honored to be sharing this podium with him today. We ran through the review. We will apologize if we don't cover everything. I direct you to all the written materials that Anuska has posted and the New York State Unified Court System. I will be referring to the rules of professional conduct. I know that's a no-no, but all of us need to know it in our daily practice as attorneys. So if I reference a canon, you can reference it there. I won't recite the whole thing in respect to time. Any questions, you could put it in the question area, and everyone is on mute. We will try to address it at the end. If not, Anuska will be placing our email addresses in the chat room, and feel free to contact us even if it's not in conjunction with what we're discussing today. I will be a busy lady for AmTrust. We decided last week, the whole month of November, probably every week, I will be doing this continuing series of CLEs, one on selling and buying property through an estate. We're doing one on title clearance, and then we're doing one on the basics of title insurance that I've presented before, and that is really informative. Look out for Cornerstone Part 2. Peter and I will be returning. We're waiting for certification for diversity, equity, and inclusion in real estate, which is very relevant to what's going on today, and it's required as per the DEI CLE requirement for all New York State attorneys. We're excited about that one, as I presented that one last week, and lots of exciting information. So on that note, let's get started. As a real estate transaction for residential, we have even been busy throughout COVID, although we've been doing a lot of social distance and remote. I understand from realtors, open houses can be a crazy place. 10 couples can appear at a doorstep, and within 1 hour, everybody is fighting and arguing and paying over the asking price. So I will start this discussion with the role of real estate brokers. As attorneys, we will get a call that a client's standing at an open house and they're signing their lives away. we don't want them to do that. I would ask them to sign a broker's agreement subject to purchaser's attorney's approval. A lot of the younger attorneys, I tell them that nothing is final until the contracts are signed by the seller and the down payment is deposited. Even then, you don't know. Even then, buyer's attorney might get a call after all those negotiations that they found somebody else, and then you're going to have like a pricing war. Okay, so the client is going out. The best scenario is if you know your client is looking, and you could advise them before they go. Here's my cell phone number, call me. We have technology now. You're standing in front of a broker, take a picture, send it to me so I can read it. Do not sign anything yet. Brokers, not to badmouth them, will take 10 binders at an open house, $1,000 down payment, and nobody's guaranteed to have the house. On behalf of sellers, there are 3 kind of real estate listing agreements if you're signing. Sometimes I tell clients, you speak English, just do it yourself. Why pay the 6% commission and lock yourself in? But if you decide to lock yourself in, know the kind of listing agreements there are. There's 3 kinds. There's the exclusive right to sell, where the listing agent is entitled to everything. If they sell it, if another brokerage firm sell it, and the most important one, if the seller sells it, if you find your sister wants to buy your house, you're still gonna have to pay them the broker's commission if that is an exclusive right to sell. An exclusive agency agreement is one where the listing agent gets the commission if he or she or another agent sells the property. But if, say, the seller sells it, finds someone on their own, you're not obligated to pay the commission. That's why this is really important. The last one is the most basic. That is an open listing entitled only to whatever agent sells the property. So basically, if you find somebody, you're protected again. I always tell the sellers, please protect yourself, because you never know who might want to buy it, and the broker didn't do very much, although I don't want to say that. And the other thing is, as everybody knows, 6%, it's very negotiable, broker's commission. And just be aware of these situations. The other thing with real estate brokers is and this is on a negative note, I had it in the first real estate transaction in my practice in 1987. My client went in with 5 real estate brokers into one new construction in Bensonhurst, 5 different people. And when I went to contract, and we did in-person contracts then, I know that doesn't exist anymore, with the builder's attorney and their lawyers in Bay Ridge, I remember it, 5 realtors showed up at that contract closing, fighting over commission. And I was kind of losing sleep for the next couple of weeks. I was suggesting they split it 5 ways, and that wasn't going to happen. It went to MLS arbitration, and then one of them slammed an LP on the property. And that's my first real estate transaction. Of course, that was horrifying for me. But if you learn something through years, and I have, a real estate LP from a broker on a residential property does not stop a closing. Okay, that is not going to, that doesn't really hold water. All right, any real estate broker that slams a lien LP on a property for a leasehold over 3 years, or on a commercial real estate brokerage, that will be a legitimate LP that a title company that Peter and I might pay attention to. Otherwise than that, under New York State Real Property Law, Section 294B, it does not create a lien on real estate if it's a residential real estate situation. Okay, and I just want that, realtors can't threaten to stop a deal based on that. In my presentation, and I'll be brief on this because we are going to do a presentation on DEI and real estate. There's 5 questions basically that realtors, I've discovered, cannot ask your clients, or the lawyers are asking these real estate brokers. It is in violation of the Federal Fair Housing Act to ask these questions, which I used to tell the clients, ask the broker. You need to do your due diligence. You need to know where you're going, all right? Ask your broker these questions before we sign the contract, okay? What kind of people live in the building or the neighborhood? No, that's a problem. They can't answer those questions, all right? Is this a good place to raise your family? Can't ask that either. It's a protected class under the Federal Fair Housing Act. Is this a safe neighborhood? Given after COVID that New York City, I live in Flushing, the most affluent parts of town have witnessed crime. What is a safe neighborhood? Okay, how are the schools here? And under what we see lately, everyone, if you're New York City driven or the suburbs of North Shore, everybody wants to live in, used to be the Herrick or the Jericho Syosset school district. It's the most in high demand, at least for the Asian buyers. Can't ask those questions, and the real estate broker can't. So you as an attorney should advise your clients, and I do this too. I do independent research, not bothering the realtors now that I realize it violates the Fair Housing Act. Can you show me a neighborhood? Like someone might ask you, can you show me a neighborhood with a lot of Asians? You can't ask the realtor that, okay? This was quite eye-opening for me after I read it. It has been litigated by the federal government. There was a big case out in Long Island now with over 200 realtors. It was cited in Newsday. Federal Fair Housing Act, under that act, they sent out testers, people purporting to be buyers, speaking to realtors in Long Island, and all of them got cited, and some of those are still on appeal right now. So as lawyers, because we're part of the team, we have to assist our clients and guide them in the right direction and not make it difficult for them in their process of buying a house. So on that note, the next thing what Peter and I are going to talk about is the role of the purchase and seller's attorney in light of ethics. And we're just going to briefly touch on a couple of things. We're going to bring up specific real situations. We've changed the names and the parties' identities. And annexed to the materials are the New York State Unified Court System's rules of professional conduct. I don't know how many of you on this call look at them. If you're a good lawyer and you know them, you don't need to look at them. If you're not sure, you should look at them to make sure that you're doing the right thing. I will cite the canon, and then you can look it up after because I don't want to read it in its entirety. And then Peter and I will talk out of our 2.5 decades, I don't like to say the amount of years, of practice as attorneys, of the things that we've witnessed and actually seen through the course of our days. Okay, so I'm going to go, as I was reviewing this before this event started, I'm just going to go in numerical order to make it easy. So rule 1.1, a lawyer should provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation necessary for representation. A lawyer should not handle legal matter the lawyer knows or should not the lawyer is not competent to handle. So Peter, you get a call at the title company from this attorney that's representing someone on buying a deal, and they do want to give the title to Cornerstone, but you've never heard of him before. So you decide to go into the Unified Court System, and you see that he's an intellectual property attorney. What is your thought on that?
My first thought is I'm going to be taking a lot of phone calls on this transaction.
That's right. I don't know if he's going to breach the canon, but as a title counsel, I've seen that, and I'm really going to help him as much as possible to even teach him. You might even be having to review the contract and everything with them at that point. But you know, you try to hope that the clients will get a real estate attorney. A lot of people think that real estate attorneys, and I've been admitted since 1986, I'm going to admit today, that, oh, it's nothing, you know, we're litigators at big law firms. We pick up real estate closings on the side to make extra income for the nannies. I've actually had people say that to me. And I have to defend us that we are special in and of ourselves, rather complex in the transactions that we do. And no.
Yeah, a lot of times you get a lot of those clients, either attorneys who are new, young attorneys just recently admitted, and you're right, you try to help them as much as you can. But if you really do see something going south on the transaction, I guess all you can do is be an advisor. Basically, you're gonna be practicing law without getting paid to practice law, I guess. On those.
Exactly. That's the problem. All right, I'm going to 1.2D. A lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is illegal or fraudulent. All right, except that the lawyer may discuss the legal consequences of any proposed course of conduct with the client. Now, I know Peter has practiced in the Asian community. I have for over 3 decades. We get this all the time. We get a contract, and I'm going with the purchase price on the contract. But then I get a call from the broker or the buyer, or sometimes the seller and the buyer together that, oh no, there's this little piece of paper that we signed, and this is what's going on. And I'm like, do not talk to me about that. I will not get involved in what I call the paper bag closing on the side. So Peter, you want to elaborate a little bit more on what I'm talking about?
Yeah, I mean, I really haven't, I can't say that I've seen it that much, because usually I think that the clients will know if they can go to a lawyer who's going to even entertain such a thing. But in my experience, most attorneys don't handle those things. It's similar to, you're not going to get any enforcement of it, and you're going to be outside of the law. It's an extra legal.
That's what I tell them. I said, let the realtor handle it, and on the all cash, whatever you're doing, anything goes awry, you're going to have a big problem. You really are. Okay, 1.3, and this happens even though we have technology and iPhones and things that we look at persistently. Even my phone sits by the side of my pillow, I'm opening it up all hours of the day. A lawyer shall act with reasonable diligence and promptness in representing client. How many times have I been hearing this whole last year during COVID, can't get to the lawyer? I think that's inexcusable. I know judges have really been on top of this right now with deadlines and everything else. You're emailing somebody and you don't hear back from them, or I'm hearing from clients, they go to contract, they're the buyer's attorney, send it and don't hear for weeks from a seller's attorney and can't get through to them. So I want to just raise to the attorneys on this CLE today. There is a rule of it in the professional conduct. So be aware of time issues and on behalf of best interest of your client. I know many of us forgot I got sworn in at the Second Department Appellate Division a long time ago. That is why we got sworn in. Your clients also have technology and they're not going to be happy if you have not gotten back to them either. You have to contact your clients. Peter and I know as title counsels, we get back to our clients. For me, it's a title agent. For him, it's an attorney or a bank or one of his clients at the title company. They are calling us for assistance, and as attorneys, we have to get back to them on a timely basis. If you don't have the answer, at least get back to them, right?
Yeah, absolutely. You're going to cause yourself more grief and aggravation down the road if you don't handle things in a timely manner. I actually give my clients my cell phone now, which is usually a mistake, but text me in a normal time frame, and I'll get back to you. You know, hopefully 9 to 6.
Well, I always try to say to clients, because I used to do immigration law, and we didn't have cell phones then. Well, yeah, you're getting deported. Yes, you need to get to me. But for real estate, unless I said nobody died and no one's going to jail and no one's getting deported. That's what I tell my clients in my 30 years. I will get back to you, but you didn't need to contact me about the power of attorney that's coming in on the title report at 3 o'clock in the morning, because there's nobody I could talk to about it anyway. I will address it 8 o'clock in the morning, but not 3 o'clock in the morning. Okay, 1.7 is the important one, conflict of interest. All right, a lawyer may not represent a client if a reasonable lawyer would conclude that representation will involve the lawyer in representing differing interests, or attorney cannot represent a party where they may benefit from the transaction. So I'll let Peter talk about what he's experienced, and then I'll go on mine.
Usually it's not as simple as a stranger who's a buyer and a stranger who's a seller both want you to represent them. Usually it's a buyer who says, oh, my friend is selling me his property and we're all friends and everything is great and we just need a lawyer. He doesn't want to get a lawyer, so we just need someone to prepare the paperwork, kind of diminishing what we do in my mind. These are always a problem. If there's two parties who are adverse to each other in any way, who are one's buying from another or whatever, there's any possibility of things that can go wrong. So besides the fact, obviously it's unethical to represent the buyer and seller in that situation, but you're opening up you're opening yourself up to, first of all, ethical complaints, but also just a complete nightmare of a transaction. If they don't want to spend money for a lawyer, first of all, they're probably going to argue with you over your legal fee, so that's usually a red flag when you're about to represent somebody. And second of all, then you're not going to get paid the way you're supposed to get paid, beyond the fact that this is an ethical violation. It's a little bit more of a gray area when it's family,
Yes.
Parents trying to deed it to a child. Definitely becomes more difficult. And the 1 or 2 times I've seen this where I've been foolish enough to accept it, there have been siblings involved who are not getting the property. Immediately at that point, a separate counsel has to be retained for the family in order to do it that way. This is not a simple, can you prepare no consideration deed for me? This is parents giving to one child and 2 other children having their noses bent out of shape over that issue. Extremely dangerous.
Peter brought up a really good point. When the family's trying to do the right thing and give it to one child, and then I always ask, are there other children? Inevitably, they don't live in New York, and then you hear the child and they go, well, they don't do anything. They live in California. You don't want to get involved. Zero consideration can be very ugly. And then by the time that they're going to sell it, the title company is going to question the zero consideration deed and say, how do we know that you fully consented to convey to that child? We might get a dispute or challenges from other families. How about the situation, Peter? We get admitted to the bar, and a lot of the young lawyers are doing this now, and I'm not stopping them from it. Of course, you get your notary right away. We get waived in, and we all did that. You can get your real estate broker's license, you can become an insurance broker, you can become a mortgage banker, and that's all fine. But what happens when you see a transaction where that one person with all of those hats is wearing all those hats all piled up on their head? Is that ethical?
No, the danger is
Right.
now you have a real financial interest in something closing, regardless of the interest, the legal interest of representing your client properly. So if you're making a couple of bucks on the side of a deal happening and at any side of it, that's a problem.
It's what I've told a lot of attorneys have called me, and I said, you could broker the deal, but you can't be the attorney at the same time. The client is, it's a disservice to the client, because your legal advice is going to be clouded by the fact you're getting a huge commission on it. They do admit the commission is larger, so they said then you need to retain counsel, okay, and and do the right thing. And I start citing the canons. In terms of the one represent a party where they stand to benefit from the proceeds of the outcome of the transaction, I always tell the story. It was a title experience of mine. Attorney was representing a woman selling her home, was in a huge rush to sell the home in South Ozone Park. They claimed the husband was missing in Greece, like he fell off a sailboat like 30 years ago. We don't know where he is. The couple was never divorced, and the attorney is rushing us to close. I don't even want to name his name. And I couldn't understand. I said, I can't. And I remember it was Fidelity. We couldn't insure it because the husband's name is on the deed, unless you show me a death certificate, which I say title is always morbid, Peter, how sometimes we'd rather see a death certificate, and that'll take care of that vested interest. Couldn't do anything. And he was really upset. I didn't understand. He seemed very personally, emotionally involved in this. And it was impossible to deal with him. They scheduled closing, which I did not approve of. And I get a call from a woman, ironically, the woman went to law school with me. I remember her. And she's representing the husband who came back from Greece. So he's alive and well. Evidently, the neighbor saw the for sale sign and knew where the husband was. And the wife, the husband's lawyer calls me, my classmate from New York Law School, explaining the situation. They are estranged and separated, but the lawyer that's being so aggressive with me impregnated his wife and is expecting to have a child out of wedlock. It's a true story. And that's why they want to sell the home and he wants to move on. But if you think about it, they're not divorced yet. Very ugly situation. I was actually at the point, because I'm the title counsel on it, I don't know whether we should have been reporting his misbehaviors or whatever, but it's certainly something like that can cloud an attorney's judgment on things. We're going to now go to one last section and then we'll move on. Let's see, section 5.5. Oh, 8.3 is reporting professional misconduct. When you see something happening, okay, what is your obligation? We saw this at a closing once. A long time ago. It was Cullen and Dykeman. And misconduct, the attorney that came in was screaming and cursing at all the other attorneys in the room. Okay, and this was I've been admitted over 30 something years. Remember Chemical Bank, big commercial closing. He really was going after everybody, and I didn't think that was behavior becoming of an attorney. I didn't know about 8.3, but all the lawyers went out to the parking lot. I remember it was Jericho Quadrangle, and some of the ones that were then older than me were going to report him to the second department, and actually they did. So yes, under 8.3, you can, that affects the trustworthiness, fitness, the honesty of an attorney, all right? You can report them. I won't name another colleague of mine. I don't want to do that, but he did that at a closing a couple years ago, and he was suspended for 4 months for screaming and shouting and demeaning a client at the table. Okay, so that is not a good situation. All right, under 8.4 is the last one I'm going to talk about. A lawyer or law firm shall not violate or attempt to violate the rules of professional conduct, engage in illegal conduct, engage in conduct that is prejudicial to the administration of justice. And G is what's important. We raised this. I had one attorney just specifically directing herself to talk about this at a diversity, equity, inclusion CLE. A lawyer or law firm shall not unlawfully discriminate in the practice of law. This is why we are now required under New York State to have a diversity, equity, inclusion CLE credit on our license. Unlawfully discriminate in the practice of law, including in hiring, promoting, or otherwise determining conditions of employment on the basis of age, race, creed, color, national origin, disability, marital status, sexual orientation. that can come before the first or second department if you do so. I know it has no relation to real estate. However, I know there are a lot of people that have their own practices. I did one of these DEIs out in Garden City at the Nassau County Bar, and the lawyers raised their hand. They've been in practice 30 years. What do I have to hire a woman of color for? I don't have to do that. I had 2 judges sitting in the audience, and I remember I said to him, that's why you're taking a DEI CLE in front of me. You need to. Even if you just interview them, you have to open up your hiring practices. That isn't good. That is totally not appropriate. Okay, on that, Peter is next going to talk about power of return, reviewing purchaser and sellers closing costs, and the topic of FERPTA. And if you want me to share the FERPTA conversation with you, I'd be happy to do so, Peter.
Great, thanks, Margaret. So one of the most important things I do when taking out a new client is going over all the closing costs of the transaction. Usually, you want to make sure that the client is going to be able to afford the transaction for the case of a purchaser, of course. So I think it's important to get an estimated title bill, also to figure out if there's a mansion tax situation, if it's out in Suffolk, if the Peconic Bay transfer tax comes into play, and also get a general idea of the buyer's finances. I'll basically say, listen, you're putting down 10%, you're gonna have to come up with another 10% at closing, and closing costs will be however much, giving them a sort of itemized list that I present to every purchaser. If it's going to be $120,000, including the down payment, and they don't have that money in the bank, you may as well find that out right away. Likewise, you want to go over the fees for the seller, even though in theory they're going to be making a profit on the property. You want to make sure that they're aware of what all the closing costs will be going into it. The IT 2663 comes into play at this point. I know Margaret has a section where she says we should know our client. So it's a very important rule of thumb to always get a copy of the client's ID. As soon as you see a Massachusetts or a Florida ID, red flag should go up, and you should explain to the client that there's a potential that they're gonna have to pay the IT 2663 for a foreign non-New York State resident. You just don't want to have any surprises at the closing. And I always feel like if there are arguments at closing, I mean, not everything can be covered. And I see arguing happening a lot less frequently now than I did 20 years ago. I think it's just because lawyers are showing up to closings much more prepared. So again, that to me, if there's an argument at closing, either something went wrong from the time you signed the contract to the time you went to the closing, or something wasn't disclosed properly going into the transaction. I just think the open lines of communication with the client includes giving the total fees of everything that's involved. And FERPTA obviously also comes into play. This is an area that I probably get a call maybe once every 3 weeks where we have non-US citizens selling. And I'll let Margaret go into her FERPTA story.
What has happened before COVID is that, and now I'm actually doing an event on the Pandora Papers, which came up in the news a couple weeks ago. Huge foreign government money coming into this country to buy, and now they're going to flip it and sell, but they're obviously not U.S. citizens. Under FERPTA, there has to be withholding tax paid to the U.S. IRS. All right, so it is in the contract of sale and residential. Sometimes people forget about it, and then some people forget to take the FERPTA affidavit at closing that they are a citizen of the United States. That little piece of paper is extremely important, and I'll tell you why. Okay. So normally what we do is, now the title company does not get involved. Our underwriters, I'm an underwriter, have advised the parties, we do not get involved in FERPTA. Okay, so what do you do? And I actually I remember had a CLE where the attorneys knew. The buyer's attorney will hold 15% pretty much, or if you need a little bit more cushion, of whatever the seller's liabilities are going to be. And then the seller will submit the return, and then you have the money safely put away to pay it. And why is that important? Because I will cite the situation. There was a title company in New Jersey that did New York closings, called their underwriter on a $3 million deal in Woodbury residential, and the underwriter said, do not touch this. All right, buyer's attorney is to take the escrow for the FERPTA, sign an indemnification between the parties, and wasn't that in the contract of sale? And what the agent did is, because the client who's the buyer's attorney did not want the buyer's attorney to be inconvenienced, took $30,000 in escrow at closing, contrary to what their underwriter told them, all right? and the seller went back to China, okay? And the seller's attorney was in Mineola, did not even speak Chinese. That was surprising me. I guess the paralegal spoke Chinese. So IRS audits after, comes in with a letter going to the buyer, not the buyer's attorney. The buyer was a recipient of $150,000 in liability for FERTA. They, of course, ran to the title company, and then the title company has $30,000. So I get the call on advisory, what do I do? And I said, you shouldn't have done that to begin with. You under escrowed, and you weren't supposed to escrow. And he wanted me to help him call IRS. I said, IRS isn't going to negotiate, and you're going to open up a big box right now, okay? I called the major CPA firms that I know that work with me at the Asian bar, and they said, what's going to happen now is if they can't find the seller, the liability will fall on the buyer. That's why the buyer was a recipient of this letter. And that is totally unfair, because that should have been addressed at the table. So I always bring this up at closings, don't. And unfortunately, the FERTA always comes up at the closing table. Like Peter said, you'll get calls. This should be addressed at contract. And the other thing is, you may not know, so that's where it goes. You need to know your client. Ask if they're U.S. citizens. Ask for their driver's license. I mean, you can ask these questions because there are going to be different issues right now in terms of liability. This is a huge. I mean, if you think of what I just said, that's a lot. And penalties and interest we're running. It is not negotiable. And the buyer was really unhappy, and then the buyer wanted to know, can he bring a claim against the underwriter? And the answer is no, because the underwriter's instructions were do not escrow. So I always need to stress this, so important, because again, not everybody. And then I get the question, can foreign people buy? Yes, they are aliens, but not like Martians from space. They can buy, and Peter knows this, they don't even have to have an SS social security number. They are allowed to buy property in the United States. But when they sell, there's certain ramifications. They have to pay withholding tax. Okay. Let's see, what do we got? Peter, let's see, what do we got next on the list?
We have a couple of quick questions.
Sure.
The first one is, can an attorney take an equity interest in a client's business? My understanding is no, and there's always the fear of the practice of law by non-attorneys, but if it's a non-legal business, I guess the question might be more of a gray area. But in my opinion, that I don't believe an attorney can take an equity interest in a client's business.
Oh, is that what it? No, that's more like where I said you can't profit. I had an interesting situation, no relevance to real estate client. I was doing a Carvel ice cream deal like 20 years ago, and the buyer's attorney pulled out of the deal, and the buyer actually admitted to me, oh, he didn't want me to buy the Carvel from my friend. It was a friend's deal. He wanted me to open a TCBY yogurt store with him. I knew better. I said, he's suggesting that you break, he's representing you, and now he's going to go into business with you. And actually the client admitted to me, I wasn't happy with that. Are lawyers allowed to do that? And I said, no. So it is a very gray area, but be very, very careful. If you want to address that with me offline, I do. I had a lot of cases from the Bar Association that I didn't, we don't have time to read it, where that happens. And I know it's happening now because attorneys are branching out beyond their law practices. So be very careful, especially about going, your clients want you to go into business with them. You can go into business with them, but you can't practice law simultaneously. You can't be their counsel unless you're going to be their 100% in-house counsel. You know what I'm saying? Be very careful about that. I must stress, and Peter would agree with me, your license are precious and sacred, at least mine is, for all the years that I've practiced, and you do everything you can to hold them close to your heart and not to tarnish them, okay?
Just one other, asking if on a sale of a New York co-op, if a seller is in another state due to COVID, if the IT 2663, actually a co-op is 2664, I guess. But if it's necessary, and if they've lived in the state 2 of the last 5 years, it would not be necessary.
Oh, is that the one where we feel that you haven't lived and you're subject to on the TP 582, like was it I-2663, right?
But I think you can sign the back of that the fourth page of the TP 584 because you've lived, the clients lived it.
I think they're giving, hopefully finance is giving consideration to the social distancing aspects of COVID. I mean, that's why a lot of people moved away. I mean, they were intending to come back. I think it's more so for the people, like we get the ones where the broker says the closing, oh, they haven't lived there for 2 years. They rented it out. They're in Florida. That's a totally different situation where we're going to take the withholding tax from you, which brings up, that person brought up a good point, that, ask if the seller is living there. I mean, at least for the benefit of the buyer, but also for our transfer tax reasons, right? Are they there? If they're not there, then we're going to have to take it. I remember when that first surfaced over 15 years ago, it was hell at a closing when those forms came out, and people were very upset that we had to collect that extra money. But these are the costs that Peter is correct, need to be reviewed in advance, particularly mansion tax. You know, and sponsors, we'll talk a little bit about buying new construction. Remember, the transfer tax is going to fall on the buyer unless you can negotiate it. And I've seen it being negotiated because of COVID. But buyer needs to know. So title companies are readily available before even the contracts are signed to help get you an estimated bill if you want to review that with a client. And I suggest that you do. I mentioned to Peter, I even review a title report and what a policy is with my client. I know a lot of the people on this attending today might think that's overkill, but they are paying a huge bill on a premium. They need to know what they're getting at the closing. Okay, any other questions, Peter?
A couple others that might take a little bit too long to answer, so I'll welcome
Okay.
emails sent to us.
Okay, why don't
we'll-
we proceed on, and we'll try to make some time. I'm watching time to have to review the questions after. Let's see what we can
Sure.
do. Okay, so Peter is going to talk about power of attorney.
That's probably the scariest words you hear in the title right now is power of attorney. I guess it's probably because the most often you'll see power of attorney involved with fraud. It's probably why attorneys get so angry at title companies when we're being about the power of attorney. Obviously, I mean, the rule I learned right out of law school as a new title closer was I had to speak to the grantor of the power, make sure that they know who they are. I would usually find some sort of question that only the person who owned the house would know. Ask them a property address, ask them, hey, you're selling your house today, why are you selling it? Something along those lines, just to make sure I'm speaking to the correct person. Obviously, there's conflicts with powers of attorney. Husband gives power to a wife. The wife is going to deed the property from husband and wife directly to the wife. That's a huge red flag. I don't even know under what circumstances we would allow that to happen.
Exactly.
Very important that the power of attorney form has been changed and now requires 2 witnesses. So sometimes we'll see someone bringing out their old power of attorney that they use their typewriter in their office to type up, and it's a 1987 power of attorney. Obviously, that's not going to fly. Of course, when you're getting the power of attorney executed, we welcome you to send it to us, the title company, to review, and we'll take a look and make sure it's the proper form. Simple things like the name of the person on title does not perfectly match the name on the power of attorney, which will cause a problem for us. And then finally, when you're doing the power of attorney execution, you should get a copy of the photo ID and make sure that you should do your due diligence as the attorney when you're taking a power of attorney to make sure that the questions that the title company is going to ask, you're going to be able to answer intelligently. These are where the frauds take place on powers of attorney. And that's why every underwriter in the world is paranoid of them. And don't yell at us when we're being careful. We're just trying to protect people's. You can yell at us anyway. We're going to do it anyway.
We actually, and people, even through COVID or even before COVID, are surprised here. We will take pre-signed executed documents. I tell somebody, if you're going to send a FedEx all the way across the world to Hong Kong or whatever, you might as well get the documents pre-signed. And we're actually okay with that. We prefer that. Just clear all the docs. We send the copy of drafts of those to us before you get them signed and notarized. Okay, because once that's done, it's too late. And we'll just ask for your attorney affirmation that's still alive and well with photo ID. If there is no notary, well, if there's no embassy, and it's been difficult through COVID, some countries, and I won't go into this detail, there's something called an apostille under the Hague Convention that you can get a local notary to sign it. If the embassy is not open, you have to go, you probably should call the title company. It's on the Department of State website, which countries have under the Hague Convention apostille. And it's a very fancy thing, like I've seen them from France, comes back with a seal and some ribbons. And then we constantly going to say this to you from a title perspective. We need to make sure it's recordable in form. I can't stress that anymore. That Peter said we're rejecting. We are rejecting because the form isn't good. But if they reject the power of attorney, at the city registrar's office, we can't get any of the documents or any of the mortgage documents. Nothing will go on. The whole package is going to come back to us rejected. We are very unhappy when that happens because we need to get everything on record, especially from the underwriter point of view. Our policy is dated and we just don't want problems. Okay. So I can't stress the attorneys. Counsels are here to look at everything and review in advance. You're not bothering us. We prefer, I know good title reports will have it, but I know attorneys are not reading the last page of Schedule B to see it. Okay, I feel like maybe we should put it in the front of the title report where the cert is, but very important. And I know Peter mentioned power of attorney is not acceptable. Life estates, we need sign off, or we need a death certificate that the life tenant passed away. Fiduciaries, administrators, executors, trustees, no, that's why they're there. Can't take a power from them. And in a corporate situation, usually you as the attorney will wonder why you've been asked to be appointed secretary of the corporation to sell. That's because they cannot power out. And the worst power is what Peter said. If it's a husband and wife, and then the wife gives the husband the power, and then he deeds to himself, we call it a self-serving deed. When we're reading the chain of title, we won't even read a deed like that in. We will go back to the deed that they legitimately took title, because we just don't know if there's fraud. We're very concerned about fraud right now. And that's the reason why we're going to question that. So I know power of attorney can be a whole CLE. So any questions, just raise them and we will get back to you on that. Thank you. Now I'm going to talk about money laundering, and I always like to laugh because it has the initials ML. I did at least, I don't know how many, 6 of these on money laundering. Last week in the news, you might have heard news on the Pandora Papers, and that's all the foreign governments. China used to be notorious. Russia, several years ago, they said the AOL Time Warner building, of which I was very proud. I worked on all the title under what used to be the Coliseum. I'm dating myself in Columbus Circle. Those 2 tall towers, and I remember I got excited. I did Ricky Martin's sale of his unit. Nobody in my office needed to know who Ricky Martin was. They say those 2 buildings, cited in the New York Times, are the biggest cash cow deposit of money laundered money. Many bad federal investigations, foreign governments have just buy condos all cash. And, you know, it's a place for drug dealers, traffickers, people in illegal sales, terrorists to put their money. And we need to be cognizant of it. Basically, the real estate transactions seem to be the best place for them to park their money. And if we have FinCEN in your title report, that is the federal government's response to try to monitor all of this illegal money coming into the country right now. So FinCEN, which came in the inception 2016, I'll just talk briefly about it. All the underwriters will, we help file it, but we don't get involved in it. You'll see it as an exception title report. Initially started that it's covers residential property, anything over $300,000 or more, has to be all cash. So it defines within the FinCEN regulations anything that's all cash. If there's any part of it that is a mortgage or a loan, then it does not apply. The legal entity buyer, the buyer is a legal entity, a corporation, LLC, or partnership. Okay. Under those situations, it looks as if you could try to hide your money. All right. So basically, the GTO, and I laughed when I saw this in 2016, the geographically targeting orders went out to certain areas in the United States. And when I saw this in 2016, it was where all the affluent, crazy rich Asians, I say that with great affection, were living. It was in California, in Bay Area, Santa Clara, LA, that's where all my friends live. In Florida, it was Broward, Palm Beach, Miami, that's where all my friends live. Hawaii, Honolulu, okay. New York, it was all the boroughs. Texas was Bexar, Dallas, and Torrance. Houston, some of the affluent parts of town. Washington. So now it's expanded out to the country. It pretty much covers a lot of the transactions. A currency transaction report is filed by the underwriter. The form is provided to the clients. And that's another thing that a buyer's attorney, all right, you need to tell your clients about this, all right, that, you know, don't give us a hard time. That is required under federal law. That, and there's also a New York State document under LLCs that they have to disclose who they are. You can't hide under these shell corporations and LLCs. That is not, it's by law now that this disclosure has to happen. We do run US Patriot searches in our title report. That was an outcome of the terrorism of 9/11. And basically, you know, we're searching names to make sure they're not a specifically designated national or on the blocked persons list. And if it comes up, and I've had experience when I worked at Stewart Title and other underwriters that it has come up and an agent calls you, that's at the point you have to call the authorities. And if that person is sitting at the closing table, you've got to discreetly hold them down because they're on the most wanted list. You hope that you determine this before the closing, but I did have one year. It was in Richmond Hill in Queens. I was at the underwriter. We got the call. I had to call the Nassau County DA's office and the FBI. We had to hold this individual down the table. And it was ridiculous because it was rush hour and they couldn't get from Nassau County into Queens. I know I myself drive that route sometimes. At 5 o'clock in the afternoon is not the easiest thing. And the closer was a nervous Nelly. I told the closer what was happening, talked to them. I said, get outside the closer room and I'm going to tell you what you have to do. And they just couldn't hold. I said, don't tell them why we need to keep them there. Blame the counsel at the underwriter and the agency that there's problems and it can't close. You know, if you got to get me on the phone, I'm going to have to make something up, but you got to hold them down. The authorities are coming out. They're on the list. They're on the hit list. So it does happen in reality. So we don't make it up that we're just doing this. These are some of the things you will see in a title report, and these are the underlying reasons why they are there. Peter, I'm going to have you talk about pre-contract due diligence.
So one of the things I've noticed as a practicing attorney is the question over certificates of occupancy and what the client's actually selling. Yeah. It's similar to knowing who your client is when you're representing them. You also want to know who, what the situation is with the property. So when I have a client who says they want to sell a house and they give me the address of it, ideally if it's in the 5 boroughs, I'll go on Acris and make sure the person I'm talking to is actually the owner of the house, which sounds ridiculous, but the number of times that is more than you'd think. So first identifying who owns the property, because next thing you know is, well, it's actually my mother's house, but now she wants me to come here to discuss selling it. You're preparing a contract with the wrong person on it. And who knows if the mother is even aware of the fact that this person is here talking to you to sell this house. That to me is pretty common sense, but I don't know that everybody does obtain the last deed of record to make sure that this person has the capacity and is the right person to be speaking to. But another thing that you see even that you may not think of, and when someone's retaining you, is the certificate of occupancy on the house. I've had situations where someone's selling a house as a 2-family dwelling, and when you actually do the C of O search, which I always do when I take on a new client, the C of O is for a 1-family, or there is no certificate of occupancy. You've already signed the contract, and now you have a potential down payment fight when the person who thought they were buying a 2-family and they're really only buying a 1-family. At the very least, you're negotiating a $25,000, $35,000 credit with the purchaser, and your client's not happy. I like these things to be established right at the outset. Now, once you establish what the legal ownership is of the property, you get a C of O, and let's say all you have is proof that it was taxed as a C of O prior to 1938. At that point, I'll attach the certificate of occupancy search to my contract. No information is going to come from another title company when the purchaser orders it. That's going to be different from this, most likely, although actually, believe it or not, examiner C of O searches can vary. But odds are there won't be a difference. And we know at the outset, before we've even entered into contract, what we're buying. Once again, another situation where we're avoiding there being an argument at the closing table, which you used to see all the time, but you should see with all the available information we have today, you should see less frequently. And I always welcome all of our clients to contact us, and we'll run a quick C of O search for you. Ideally, it's not in Oyster Bay, but we'll run a quick C of O search for you, and hopefully you'll have enough time to wait to get that C of O search before you have to enter into contract.
Point well taken. I want to remind everybody from the title underwriting perspective, these searches in your title report, municipal searches, are for information only. You will see the closer market. The bad closers that mark omit, not good, because when it becomes a claim, we're not insuring that. All right, it's in there as a courtesy to assist you in terms of your contract negotiations and the issues that you have to address. You should make sure, as Peter said, you're protected in your contract. The biggest issues are zoning. A lot of developers are buying. I need even Peter's neighborhood. I'm appalled. I drive on the way home to Flushing, and they're knocking down beautiful houses in North Flushing, and I think condos or something might be going up. Check the zoning, because that developer wants to make sure you as a buyer's attorney can build whatever they want to build on it. So you can call the title company. Zoning, air rights in Flushing are a big deal now. Taxes. I can't stress more how we get this after the closing. You knock down a little Cape Cod in Elmhurst and you build a 6-story condominium, or you build a mega mansion like in Douglaston, and the taxes go up and the buyer comes back to the title company. We have accepted the reimposition of an assessment of taxes. Okay, so the buyer's attorney needs to have this conversation that if you're going to build a mega mansion, your taxes are going to go up. The assessor is not blind to all of this. That is not under our title policy to cover that. I know we're running a little short on time, so we're going to quickly run through co-ops and condos. Co-ops are shares in the co-op corporation's stock certificates. You're not buying the property itself. Co-ops, the benefit is they're more affordable, but you can't do anything. You've got a co-op board that resides over every part of your life from the minute you move in. You need their permission for everything. So you buy a condominium and you're going to get a deed to the physical part of the condominium, which is like buying a house. The problem we're having in the last couple of years I've talked about, I work closely with the New York State Attorney General Real Estate Finance Board. I teach them title, I advise them. What is the problem? Places like Brooklyn and in Queens, where there's huge immigrant developers are building condominium projects and not filing offering plans. They're selling all cash deals to newly arrived immigrants who don't know how to get a counsel, attorney, and title insurance. Basically, they bought things that do not exist. So when you search it, you're going to find the little house that used to sit there. And why are we searching it? Because their child is now going to Harvard and they want to get a refinance on them to pay tuition. And these are true stories. And we're searching it. And I'm like, OMG, they never filed. Okay, so this is due diligence. I got 4 calls in the last month from attorneys in Flushing on projects in Flushing with this issue. They have not filed any offering plans and they're going to contract and the builder wants a check cut directly to the builder. And what's wrong with that picture? That is not a good situation. So Peter, I think you and I discussed this. The attorneys have due diligence to review the offering plan, any amendments, financials, board minutes. Yes, no, there's no shortcut. Young lawyers are like, do we have to do all that? Isn't there a summary somewhere? No, that's part of your obligation as an attorney to represent. And it could be 5 pounds of materials. If you got a co-op like the Estates of Bayside, I had one last year, 5 pounds came at me. I had to review everything, and then I went to the managing agent's office and reviewed all the minutes for the last, I don't know, I went back as far as 10 years. And then the client came to me the next day and said, I don't want to buy it anymore. Oh, so much for that. But I did it. Peter, yeah. Any feedback on that?
Well, everybody's got to remember to charge for doing that. Yeah, that's illegal. That's right. That's important. Question came up. Yeah, it's we definitely need to be paid for what we do. Question came up whether with a condo we have to review the board minutes, and I'm guessing if there are board minutes for whatever entity go up, the standard practice is that they must be reviewed.
If there's litigation in the building or anything that's going to affect the buyer's common charges, right? You want to see, or maybe you're going to see, oh, this is a bad building. I don't want them moving in here. And that's also part of it too. This is not legal related. I tell the clients on condos and co-ops, tell your clients, because you remember, you can't ask the realtors, is it a good building? Literally show up, talk to the doorman, the super, when he's dumping the garbage. I had one client sneak into the laundry room on a Saturday. Everybody was there, and find out all the bad things. Stand around the mailboxes. If it's a house, drive around the neighborhood all hours of the day, because when you're there with the realtor, it's going to be the nice time of day. I've had this, people move into their house and the neighbor next door is like a freaking nightmare, particularly in Brooklyn when you have party walls and shared driveways. You absolutely need to know who you're living next to. So that's like a major problem. Co-op board approval, you know, if there's something your lawyers should know, because they can say no to you and not explain why they don't like the way you look. All right, condo waivers, and I said this to Peter, they don't automatically give you, when you're buying, the seller can't say, oh, I'm going to just get the waiver from the board, I could sell to you. I had 3 transactions at the table where the board never issued the letter, and I kept saying, don't schedule this, we don't have the waiver. And the realtor's like, don't worry, we're going to get it. At the table, the board of managers in Manhattan on Park Avenue decided to buy the unit back for themselves for $1 million to flip it. It was a deal. And that poor buyer who we issued a title report sat there, had already ordered furniture, the movers and everything. And there was nothing we could do. If I couldn't get a board waiver, we could not close. And that is a heartache. Resale versus sponsor deals are very different in terms of at least on a sponsor contract, Peter understands this too, you may not even be able to put a pen mark to it. That is, I mean, it's better now, but I remember in the 80s when I was doing this, you took it the way it is, even without a mortgage contingency. That could be a whole ceiling in and of itself, but look at all the documents. And if you're not sure, you can call your title company. The counsels like ourselves probably know pretty much how to look at these things. Be aware of sponsor situations that you're going to pay transfer tax. If there's the wine cellar, the cabana, the parking space, all of that is going to be extra. And Peter, it may ramp up that bill at the closing. We just can discuss that briefly, but surprise, surprise, sometimes buyers are very dismayed. The title bill is revised at the table because all these extras decide to come in.
Yeah. Again, giving the estimated bill is always important at the outset, but as far as I'm concerned, as long as each expense is justified and there's also a justification for why it wasn't known prior, so it's not like the old, you know, you go to get you go to buy a new car and then you go in the back with the business manager and he adds the undercoating fee or whatever else. As long as it's being done and there's a justified reason for that, then you know, I explain that to a client. You know, I get it because I have to do it too. But that there should be an explanation for every fee, and you should ask the title company what the explanation is for the fee. I take those calls, and I'm always happy to take them and to explain the situation. I never want anyone to think that there's any flim-flam going on the title bills. So,
Absolutely. We're here to help everybody. The last subject was the best. I said the best for last, but it's hard to talk about in 5 minutes. And perhaps maybe Peter, we have so much. I've done this separately for 1.5 credits. We might do it. We're going to just talk briefly on cybersecurity and real estate fraud. I just took all of my AmTrust required cybersecurity. We call it AmTrust University. We take all these required courses on my cybersecurity. So I am aware that I have to be careful of phishing, and that's not phishing for seafood and fish. Hackers are out there looking at our computers, so you must make sure you have all the software protecting it. Don't open up strange emails coming to you, especially for me at AmTrust. I open up a strange email, I might be contaminating thousands of colleagues in my company and their laptops. I remember that happened with me at an underwriter one year. It was coming to everybody, and then someone pressed reply all, and it hit. Everybody got contaminated. It was a nightmare. They are out there. Cyber fraud is rampant, particularly as a result of COVID. We're all working remote. We're all glued to our laptops. Be aware of alerted to any emails coming in. Change your passwords. The bad guys are looking at your phones. All kinds of things are happening. And I did last year. Practitioners and firms should have cybersecurity insurance. If the premium's not a lot, it will cover in case something happens. So here's an example. There was the Bain case I talk about. It was from the Midwest. It went all the way to U.S. District Court. Broker was helping because it's an escrow straight. Tell the buyer what proceeds they have to bring to a closing. So the broker opens up a wiring instruction. She didn't think that it looked kind of strange. She didn't think that it looked like it was from an individual she never dealt with before, and she took it, forwarded it to the buyer, and the buyer wired out $200,000 to this phishing hacker. Okay, they found out after because it never made it to the right place for the closing. The buyer's educated individuals suing everybody in sight, and it went all the way up to the federal U.S. District Court. And District Court held, he even sued the bank for sending it, held that it was the broker's fault. And the broker, you know, acted like the broker should have been more cautious and used due diligence in calling for the instruction. That's what we do at title company. We call to verify anything coming in, all right? And basically, the bank is not at fault because the bank did what they did. They sent out wiring instructions. And I use this as an example for anything we do. You cannot complain to a bank. Barbara Cochran was hit this year with a miswiring of over, I think it was over $500,000 with Citibank. She tried to sue the bank, and the bank said, we're doing our job. You send us wiring instructions, and that's what we're doing, okay? The Judge Lori Sattler case, she buys she sells her co-op for $1.5 million, buying a condo a couple of days later, and she gets a wiring instruction from the Middle East, literally, says send the wires to this bank in China, and she sent a wire of $1 million. She's a judge. We always use this case. It was in the Daily News. She didn't question it. She didn't call it, and she wired out $1 million, and it was gone forever. So very important to be careful. Check the resources of what's coming from if you're not sure. And I'm going to have Peter talk about mortgage payoff letters because I'm sure he looks at them a lot. We are very concerned about who we are paying off, and no mortgage payoff is nominal nowadays. So Peter, take it away.
I know we're after 11. We're taking up your time, so I'll give you 30 seconds. One thing I can warn is payoff letters are now being prepared. Counterfeit payoff letters are now being prepared, where the entire payoff letter looks like any other company, any other banks, or the typical bank payoff letter, except that the wiring instructions and the phone number to call to confirm them have been changed. We have actually seen this for other attorneys who've asked us what the deal is and why this is taking place. And we're getting a lot of horror stories from numerous title companies and underwriters throughout the industry of this having occurred. It all came up during COVID. I guess people weren't operating in their usual manners in their own offices, and maybe acting remote or working remotely, so it made it easier. But it is going on, it's happening. I cannot warn you enough against being prepared for counterfeit payoff letters. It sounds crazy, it sounds almost impossible how someone has the power to do this. Could be inside jobs at the banks, but it is happening, so please be on alert for it. We are
Look really authentic. I mean, I've seen it like a Bank of America. You would have never questioned it, but my assistant I said, no, we have to call. And she didn't want to call. She was in a hurry. I said, no, we have to call. And then basically we had last minute, somebody called to change. If someone's changing wiring instructions, be really suspicious of that. I remember an assistant in my office 3 years ago jumped up in the air like, oh my gosh, they changed the wiring instructions. I ran out of my office and go, why? And I looked at it, I go, no, and don't even open that link. Somebody had intervened. A lot of times people know there's a transaction going on, and this is what happens along the way. It's horrible. I know we're at 11:01, and I promised Peter, people may not know of this for deed fraud, and it's true. The county clerk, our good guys down there, the gatekeepers, as long as it's an order, they'll take that deed. So the deed of, they did a test thing 10 years ago that someone sold the Empire State Building. It was sold by King Kong to Fay Ray, witnessed by Willie Sutton, and the county clerk in Manhattan took it. It was proper informed. They're not questioning it. They're taking it. What do you do to prevent that from happening? There is the notice of recorded document program. The city register has a special, you as a homeowner can register your name under your block and lot. So anytime something comes up, you're going to get an email. So if someone forged your name and sold your home, or someone slammed a mortgage on it, you're going to know. And I think that's the best advice I want to give to all of you today. That is, I guess, within New York City. And if you have any questions, let me know. I do work with the fraud divisions at the New York State Attorney General's office. That's Letitia James, as well as all the district attorney's office. I've done events. They are there to protect everybody, working hard on it. And as a homeowner, this is the biggest investment that all of you have. So please protect it. Thank you so much for joining us today. Thank you so much, Peter. We're going to do this again because it was delightful to be sharing the podium with you. Look out for the next invite from AmTrust, but also look out for Diversity, Equity, Inclusion, Real Estate. Again, partnering with our very good agent, Cornerstone Abstract. Thank you, everybody, and have a great day.
Thanks. Bye.